Hello dear students, I, Dr. Anuradha Goswami, Senior Assistant Professor, Department of Commerce from the Bhopal School of Social Sciences, welcome you all for the second module of this video presentation titled The Indian Companies Act 2013. The subtopics covered in this module includes formation of company, memorandum of association, article of association and prospectus. I will begin this presentation by explaining the procedure for formation of a company. Every company, public or private, has to be registrar with the Registrar of Companies known as ROC. The whole process of the company formation may be divided into three distinct stages, namely promotion, incorporation, also known as registration, and commencement of business. Promotion is the first stage for formation of a company. Promotion of a joint stock company starts with the idea of carrying on a business conceived by promoters. Promoters are persons engaged in one or the other way in the formation of a company. Next, the promoter makes detailed study to assess the feasibility of the business idea and the amount of financial and other resources required. When the promoters are satisfied about practicability of the business idea, they take necessary steps for assembling the business elements and making provisions of the funds required to launch the business enterprise. The second stage is incorporation. A company cannot be formed or permitted to run its business without registration. In fact, a company comes into existence only when it is registered with the Registrar of Companies. For this purpose, the promoter has to take the following steps. Step number 1, approval of name. It has to be ensured that the name selected for the company does not match with the name of any other company. For this purpose, the promoter has to fill in a name availability form and submit it to the Registrar of Companies along with necessary fees. The name must include the word limited or private limited at the end. Once it is approved, the promoter can proceed with other formalities for the incorporation of the company. The second step is filling of documents. After getting the name approved, promoters makes an application to the Registrar of Companies of the state in which the registered office of the company is to be situated for registration of the company. The application for this registration must be accompanied by the following documents: A. Memorandum of Association, B. Article of Association, C. A list of persons who have agreed to become director with their address, D. Written consent of the proposed directors to act in that capacity duly signed by each director, E. The notice about the exact address of the registered office of the company, F. A copy of the name approved letter received from the registrar of the company, G. A statutory declaration that all the legal requirement of the Companies Act in regard to incorporation have been complied with. The third step is payment of filing and registration fees. Along with the above document, necessary filing fees and registration fee at the prescribed rate are also to be paid. The registrar will scrutinize all the documents, and if he finds them in order, he will issue a certificate of incorporation. The moment the certificate is issued, the company comes into existence. So, this certificate may be called as the birth certificate of a joint stock company. Now, the final stage is incorporation. The Company Amendment Act 2015 has omitted Section 11, which deals with the certificate of commencement of business. Hence, now every company shall commence its business immediately after the incorporation of business. Now, dear students, I will explain the three important documents required for the incorporation of joint stock company. I will begin by explaining the meaning and content of first document, that is Memorandum of Association. The Memorandum of Association is a document which sets out the constitution of a company and is therefore the foundation on which the structure of the company is built. Now, let us see at the content of the Memorandum of Association. Section 4, subsection 1 of the Indian Company Act 2013 states that the memorandum of a company shall state the following information. First one is name clause. The name of the company should be stated in this clause. A company is free to select any name it likes, but the name should not be identical or similar to that of a company already registered. It should not also use words like king, queen, emperor, government, bodies and name of the world bodies like UNO, WHO, World Bank, etc. If it is a public limited company, the name of the company should end with the word limited, and if it is a private limited company, the name should end with the words private limited. Second clause is registered office or situation clause. Section 4 lays down that the name of the state shall be mentioned in the memorandum whereat the registered office of the company is to be situated. Registered office means a place where the common seal, statutory books, etc. of the company are kept. The company should intimate the location of registered office to the registrar within 15 days from the date of incorporation or commencement of business. The third clause is object clause. This clause specifies the objects for which the company is formed. It is difficult to alter the object clause later on, hence it is necessary that promoters should draft this clause carefully. This clause mentions all possible types of business in which a company may engage in future. The next clause is liability clause. This clause states the liability of the member of the company. The liability may be limited by shares or by guarantee. This clause may be omitted in case of unlimited liability. The next one is capital clause. This clause mentions the maximum amount of capital that can be raised by the company. The division of capital into shares is also mentioned in this clause. The company cannot secure more capital than mentioned in this clause. If some special rights and privileges are conferred on any type of shareholders may also be mentioned in this clause. The another clause is association or subscription clause. It contains the name and address of the first subscribers. The subscribers to the memorandum must take at least one share. The minimum number of members is 2 in case of private company and 7 in case of public company as subscriber to the memorandum of association. Nomination clause. This clause is included only in the memorandum of one-person company. Under this clause, the subscriber to the memorandum mentions the name, father's name, address and age of another person known as his nominee, and also states that in the event of his, that is sole member's death, such another person shall be the nominee. Now students, I will discuss the meaning and content of second important document required for the incorporation of joint stock company, which is Article of Association. The Article of Association of a company are its bylaws or rules and regulations that govern the management of its internal affair and the conduct of its business. The memorandum lays down the scope and power of the company, and the article governs the way in which the objects of the companies are to be carried out and can be framed and altered by the members. The article should contain generally the following matters: exclusion wholly or in part of Table F, adoption of preliminary contracts, transfer and transmission of shares, alteration of capital, meetings and rules regarding committees, directors, their appointment and delegation of power, borrowing power, dividends and reserves, accounts and audit, and finally winding up. The third document required for the incorporation of joint stock company, especially which is a public limited company having share capital, is prospectus. Now students, I will explain the meaning, content and type of prospectus. Prospectus is an offer document or information brochure issued by a public company used for inviting offers from the general public for subscribing its shares. It contains all the material information as to the price and number of shares, convertible shares being offered for sale to the public, which helps the investors to take a rational decision regarding the investment of his or her funds. Address of the registered office of the company, name and address of company secretary, auditor, banker, underwriter, date of the opening and closing of the issue, declaration about the issue of allotment, letter and refund within the prescribed time, a statement by the board of directors about the separate bank account where all the money received out of shares issued are to be transferred, procedure and time schedule for allotment and issue of securities, capital structure of the company, main object of public offer and terms of the present issue, details of directors including their appointment and remuneration, particulars relating to management perception of risk factor specific to the project. Now, let us see the types of prospectus prepared by the joint stock company in India. The various types of prospectus are deemed prospectus, abridged prospectus, red herring prospectus and shelf prospectus. I would now conclude the second module of the Indian Company Act 2013 by thanking you, dear students. I hope this video presentation will help you to comprehend all the concepts related to formation of company, memorandum of association, article of association and prospectus.